You've been told for years that the Supreme Court protects your right to carry. But that just changed. And not the way you think. This new 6-3 ruling just flipped concealed carry law upside down. And here's the part nobody saw coming. The majority wasn't led by Thomas, not Alito, not Gorsuch. It came from Justice Amy Coney Barrett, and she teamed up with the three most liberal justices on the bench to make it happen: Kagan, Sotomayor, Jackson. That alliance just created a brand new legal test for the Second Amendment, and most concealed carriers have no clue what it means. If you carry every day, if you train, follow the rules, and think you're doing it legal, you could still be walking into a felony because of this decision. Some states just lost their authority to ban carry on private property. Others gained the power to create new zones where your permit means nothing. And it all starts now. So let's break this down. No media spin, no politics, just straight-up facts that matter to anyone carrying a gun in America. Number 5. The political firestorm nobody expected. What just happened at the Supreme Court has both gun rights groups and anti-gun organizations scrambling to figure out if this is a win or a loss. And that says a lot, because this decision didn't land where anyone expected. Gun owners of America came out swinging, calling it a full-blown betrayal of constitutional principles. Their position? The court just handed states a legal pathway to bury the Second Amendment under layers of sensitive area restrictions and balancing tests. They see it as judicial activism, plain and simple. But here's the twist. The NRA actually praised Justice Barrett's majority. They said it was a sensible approach that still defends the core right to carry, while giving states the flexibility to protect public safety. That kind of split between two major pro-gun organizations? That's rare. And it tells you this decision shook the foundation of the gun rights movement. Now, over on the anti-gun side, the Brady campaign couldn't even keep their messaging straight. In the morning, they celebrated the court's approval of new sensitive zones. But by afternoon, they were attacking the part that struck down blanket private property bans. Why? Because that one change reopens the door for concealed carry in thousands of privately owned businesses. And the most jaw-dropping moment? Justice Clarence Thomas, who almost never speaks publicly outside the courtroom, issued a blistering statement criticizing his own court's ruling. He called it a dangerous departure from originalist constitutional interpretation, and warned that this new standard gives unelected judges far too much power to decide where Americans can and can't carry. That's unprecedented. A sitting justice blasting a decision his own colleague wrote, and doing it in public. Meanwhile, Democrat lawmakers are completely split. Some are praising Barrett's balancing test. Others are attacking her for striking down statewide bans. And Republicans? They're furious that a justice they appointed just rewrote the Second Amendment's legal framework and teamed up with 3 liberal justices to do it. Even constitutional law professors are admitting they don't know how to teach this. Because the traditional liberal-conservative split that defined the court for decades just collapsed. This wasn't just a legal decision. It was a political earthquake. Number 4. The state-by-state legal meltdown. Right now, governors, attorneys general, and state legislatures are in full-blown panic mode. And here's why. They've got 60 days to rewrite decades of concealed carry laws or face automatic federal injunctions. 12 states had major portions of their gun laws wiped off the map overnight. These were states that tried to ban carry on all private property open to the public. That's now unconstitutional unless posted with clear signage. Meanwhile, 8 other states just got legal cover to enforce new carry bans in sensitive zones, like schools, stadiums, transit systems, and government buildings, all thanks to the court's new balancing test. New York wasted no time. They called an emergency legislative session just hours after the decision dropped. California? They're racing to reclassify as many areas as possible as high-risk zones to lock down carry access before the 60-day window closes. Texas took the opposite approach. They're expanding constitutional carry in response to the ruling, using it as justification to remove what they call outdated restrictions. Massachusetts is doubling down, pushing new laws to make more public spaces off-limits, even trying to define entire downtown areas as sensitive zones. Same with New Jersey. They're building the most restrictive post-ruling framework in the country. And here's where it gets chaotic. Some states are filing emergency motions in federal court asking for clarification on how to apply this new legal standard. Others are spending millions on constitutional law consultations, trying to avoid lawsuits from both sides, gun owners and gun control groups. Florida went all in. They eliminated all permit requirements for concealed carry, saying the new framework supports permitless carry, as long as certain safety conditions are met. And through all this, carry permit holders are stuck in the middle. The laws are changing faster than most states can publish updates. Some restrictions are now void, others are still in effect, and no one knows which applies where. This isn't just a policy shift. This is the most unstable moment in state-level gun law since the founding of the Republic. If you're traveling state to state, you better know where the legal ground just shifted, because one wrong step could get you charged under a law that changed last night. Number 3. Massive changes to carry zones and permit reciprocity. This ruling didn't just tweak a few state laws. It completely redefined where you can legally carry and how your permit works across state lines. And most people aren't ready for what that actually means. Let's start with the shift on private property. In states that used to ban concealed carry by default on private commercial property, that rule is now gone. From this point forward, unless a business posts clear signage that says firearms are prohibited, you have the right to carry inside. That alone reverses carry restrictions in places like New York, Maryland, and Hawaii. But here's where it gets complicated. Justice Barrett's opinion introduced a new category of government-approved restrictions called sensitive areas, and states are moving fast to take advantage of it. Some of the locations already being locked down include 1,000-foot perimeters around schools, public transportation hubs like subway stations and bus terminals, large entertainment venues such as arenas or amusement parks, and government offices including courthouses, licensing bureaus, and social service buildings. On top of that, several states are trying to designate high-density commercial districts like shopping malls and downtown zones as off-limits. Their legal argument is that heavy foot traffic creates a unique public safety risk. And it doesn't stop there. Under this new legal framework, states are now authorized to require extra training, carry insurance, or specialty endorsements just to enter certain zones while armed. This creates a tiered carry system. Your standard permit might let you carry in a grocery store, but not inside a stadium or mass transit system unless you meet additional conditions. That kind of system never existed before. Now, every concealed carrier has to figure out what tier they fall under depending on where they're going and what the local law requires. And that leads us to reciprocity. This decision forces states to recognize out-of-state permits unless they can prove a compelling public safety reason not to. That sounds good on paper, but the catch is in the word compelling. Because every state gets to decide what that means. Some states will honor nearly every permit. Others are already drafting rules to deny reciprocity based on local crime rates, population size, or policy preferences. So even if your permit is valid nationwide, you could still be blocked from carrying in places that decide your training or background check isn't good enough. The bottom line is this: you now have expanded rights in most private businesses, but you also face a growing list of restricted zones that vary by state. And if you travel across state lines, your permit might not mean what you think it does. You need to check the law before you go, or risk stepping into a zone where carry is now a felony. Number 2. The new practical carry standard explained. Forget everything you thought you knew about how the Second Amendment is applied in court. This decision just buried the historical test from Bruin. and replaced it with a brand new legal doctrine. Justice Barrett called it the practical carry standard, and it flips the burden of proof in a way that changes how every single carry case will be judged moving forward. Under the old Bruin standard, courts had to look at whether a gun restriction existed in or around the year 1791. If there was no historical precedent, the law was considered unconstitutional. That gave gun owners a massive legal advantage in court. But Barrett threw that out. Her new standard no longer asks whether the law matches the past. It asks whether the restriction creates a real, practical barrier to your core right to armed self-defense. That one shift changes everything. Now, a state can argue that a gun law is valid if it balances your right to carry with a legitimate public safety concern. In other words, the court no longer needs to prove the law is historically grounded. It just has to show that the restriction is reasonable, targeted, and doesn't completely eliminate your ability to defend yourself. Justice Barrett laid out 3 criteria that must be satisfied. First, the regulation must serve a compelling government interest. Second, it must be narrowly tailored to that interest. And third, it must leave open alternative ways for you to exercise your Second Amendment rights. That balancing test gives states a legal playbook they never had before. Under Bruin, most regulations failed. Under Barrett's framework, many of those same laws might now survive. That includes requirements for training, insurance, location-based restrictions, and more. Justice Thomas was furious. In his dissent, he accused the court of abandoning the constitutional method laid out in Bruin. He warned that this new standard opens the door for judges to favor state power over individual rights, just by labeling something as a public safety issue. Justice Kagan, on the other hand, defended the ruling. She wrote that this approach finally allows courts to consider modern realities while still protecting the core right to bear arms. In her words, the Constitution should not force the government to ignore today's dangers just because they didn't exist in the 18th century. Legal experts are already calling this the biggest shift in Second Amendment interpretation since the New Deal era. Because it's not just about carry permits, it sets a new legal framework for how every gun law will be reviewed, from magazine limits to red flag laws to waiting periods. And that means gun owners across the country are now operating under a new set of legal rules, whether they realize it or not. Number 1. Why the 6-3 ruling changed everything. This ruling didn't just shift legal standards, it tore down the entire political map we thought we understood when it comes to the Second Amendment. And the biggest shock wasn't what the court said, it was who said it. The majority opinion that redefined concealed carry law in America came from Justice Amy Coney Barrett. But she didn't write it alone. She was joined by all 3 liberal justices on the court. That means Barrett, Kagan, Sotomayor, and Jackson stood together to create a brand new legal framework for gun rights. And the justices who dissented? They were the 3 most conservative voices on the bench. Thomas, Alito, Gorsuch. That reversal broke every prediction legal experts made about this case. Justice Barrett was appointed by a Republican president and confirmed as a conservative originalist. But in this decision, she introduced a balancing test that allows for more government regulation of carry rights than anything we've seen since the Bruin ruling. Thomas, the author of Bruin, did not hold back. He wrote a scathing dissent, accusing the majority of abandoning the historical methodology required by the Constitution. In his words, the court handed too much power to judges and opened the door for state governments to erode core gun rights under the excuse of public safety. Yet Barrett defended her opinion by framing it as a practical solution. She argued that the Second Amendment still protects the right to carry, but it does not guarantee the right to carry anywhere, at any time, without limits. Her framework tries to strike a balance between that core right and legitimate government interests. The result is the most politically scrambled Second Amendment decision in modern history. For the first time, the liberal wing of the court supported an expansion of gun rights, not because they suddenly support the Second Amendment, but because the new framework gives states more control over when and where guns are allowed. That single shift has already triggered a ripple effect in state capitals, law schools, and gun rights organizations nationwide. Because nobody knows how to interpret this coalition. Conservatives are split. Liberals are conflicted. And legal scholars are admitting they don't know how to teach this case in class. What you're looking at right now is not just a Supreme Court decision. It's a constitutional reset. The rules of the game just changed. And every concealed carrier in America is now playing under a brand new standard. This Supreme Court ruling didn't just rewrite how judges look at the Second Amendment. It changed the ground under every gun owner's feet. The rules for concealed carry just got more flexible in some places and far more restricted in others. And depending on where you live or travel, that could mean the difference between legal protection and a felony charge. For decades, we've fought to make sure the right to carry is not just written on paper, but protected in practice. That fight just entered a brand new legal era. And the truth is, most people won't keep up unless someone breaks it down, state by state, zone by zone, ruling by ruling. That's what we do here. So if you found this breakdown helpful, do me a favor. Hit that like button, subscribe to Firearms Zone, and drop a comment below to tell us how your state is responding to this ruling. Stay sharp, stay lawful, and stay free.